car crash cases, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you. Your tough legal questions answered by our experts. The attorneys with Josh Wright from the law firm of Hollis Wright and host David Lamb.
Good evening and welcome into the attorneys. Thank you so much for joining us on this Sunday evening. Got an interesting next half hour planned for you and something that we really do believe will be of interest to you. The way the show works, we have a panel of experts here ready to answer questions you have. The way that you get those to us, you see the information at the bottom of the screen all throughout the program. Also a reminder, Hollis Wright makes available attorneys standing by live right now to speak with you. All you have to do is pick up the phone and give them a call. Always good to welcome in the managing partner of Hollis Wright, Josh Wright. Good to see you, sir.
Good to see you too. And you know, we actually answer all those calls.
Absolutely.
The calls, texts, emails, whatever they are, we'll answer. We've got lawyers standing by.
Kind of have a 24-hour policy, right?
100%. We're there and available and accessible when people have legal related issues.
That's good to hear.
So that's the goal. How you doing this week?
I'm doing well. How about you?
Good, doing great. You know, we're going to do kind of a different spin on a show we've done in the past. We're lucky tonight to have Matt Griffin, who's got his own practice here in town. We're going to be talking about family law related issues as well as some support and custody related issues and divorce and kind of in that area. And it's unfortunate, the statistics are still pretty high though.
Yeah.
There is a vast majority of the viewing audience out there that has been through a divorce or is dealing with a custody related issue, unfortunately. And so hopefully some of the stuff we'll be able to talk about today will be helpful to those individuals that may have either gone through that or going through it right now.
Yeah.
So Matt, first of all, welcome. Glad to have you on the show.
Me. Yes, sir.
Really appreciate you being on. First time you've been on?
Absolutely. First time to be here.
Tell us a little bit about your practice and kind of how you got into this area of the law.
Absolutely. Well, I found my way into divorce law by being a clerk for a judge here in Jefferson County. In Jefferson County, we have 3 judges on the Birmingham division that just handle divorces. And I was lucky enough to clerk for one of those judges during law school. So that's how I kind of found my way into this area. And I'm a solo practitioner. 80% of my practice is made up of divorce law.
And so it sounds like a lot of the issues of divorce also spill over into custody and child support related issues.
Oh, absolutely.
So you've kind of got to be an expert in those areas too.
Absolutely. Custody is always a big issue whenever there's children involved. That's the #1 thing people are worried about, obviously, and then so on down the line with assets and liabilities and debts and that sort of thing.
So let's start with this, because this is an issue that always comes up when we do shows like this, and that is, how is property divided up in the case of a divorce? If someone's going to go through a divorce, how is property generally divided up?
Right. If you can't come to some sort of agreement with your soon-to-be ex-spouse and you have to have a judge decide this issue, it goes into what we call an equitable division. So that doesn't mean always equal, right down the middle, 50-50, but what would the judge think is fair in certain circumstances and that sort of thing.
All right, and so it sounds like there is an opportunity for individuals that are going through this to reach an agreement and then present it to the court. Does the court always sign off on that if both parties agree, or how does that work?
The judge always has to sign off on the agreement, but it's basically a contract between you and your soon-to-be ex-spouse about how things are going to be divided as far as your assets, debts, liabilities, that sort of thing. So everything gets thrown into the pot, outside of a few circumstances as far as inheritance and that sort of thing, but generally anything that's used for the benefit of the marriage is thrown into that pot, and you can try to work it out between them amongst yourselves and come to an agreement, or a judge will have to decide that.
One of the things, one of the reasons that we make it so easy for folks to interact with us, call, text, you see all that information on your screen, is because we love to hear from you. A question we've got here: my father started a business that I now own since my father's retirement. If I file for divorce, will I have to split the business with my wife who has worked there for years?
That's a good question. Just like I said, this is an equitable division state, so anything that was used during the marriage as a benefit for the marriage can be pushed into the divorce, so to speak. So a judge has a lot of power in divorce court to make those decisions. So if you can't work out an agreement, evidence could be put on before a court, and a judge could actually decide how that business is going to be divided between the two of you, or what stake each person has in that business.
So this concept of marital assets is really what you're talking about, isn't
Right.
it? So if someone comes to a relationship with certain assets to start with, and then they get married, are those pre-marriage assets part of the marital estate?
They can, if they're used to benefit that marriage. If that's used to, you know, it could be a vacation house that you both use, or the house that you rent out and you receive income, and that income's used for the benefit of the marriage, that would be considered part of the marriage, and it could be divisible by court.
And so ultimately, I guess, is this something that folks can go alone without counsel, or do you advise they need lawyers involved?
I always recommend that folks seek counsel in this area of the law. It's highly specialized. There's a great divorce bar here in Jefferson County and the surrounding county, so I always advise that people seek legal representation in these matters.
This is still considered kind of a specialty, though, isn't it?
It is. You can kind of get into this niche, and that's kind of how I find my way to it, is clerking for that judge and learning about this area of the law is kind of how I found it.
So if you're a client and you're out there looking for someone that understands and knows divorce law, what are some questions you think you'd want to know? I mean, do you want to know that lawyer has actually litigated through trial some of these cases to make sure that you got the right lawyer? I mean, what are some things you'd look for?
Well, as in the other areas of law, nothing beats experience. You know, you want to have somebody that you absolutely trust, sit down and meet with them. Divorce is fairly prevalent in our society, so everybody's got their issues with it, their families have dealt with it. So everybody's going to have an opinion about what your lawyer should be doing or what a judge should be doing in your case, but you just have to have absolute trust with the person who's providing you advice. And I would always, recommend that somebody go meet with different attorneys, find somebody they're comfortable with, and then just, you've got to trust that person that they're going to give you the best advice that they have.
We always get this question whenever we do a divorce-related show, and that is the issue of alimony. Let's address that. From an alimony perspective, are you entitled to alimony after a certain number of years, or is it discretionary with the court? How does that work?
Right. In Alabama, if you've been married for more than 10 years, that's when the issue of alimony can be brought up and decided by a court in that circumstance. And there's different types of alimony. We have what's called periodic alimony, which can be paid over a period of time for a period of months. You have what's called rehabilitative alimony. That's to bring somebody back up to the station of life that they're used to, that they had during the marriage. And then you can also have what's called lump sum alimony. That could be an award of a monetary amount that's just a one-time lump sum payment. So there's lots of different types of alimony, and the court has a little bit of discretion there.
Does the court take into consideration and context this idea that the education level of both parties, whether somebody's been in the workforce, out of the workforce, is that all kind of weighed into the decision?
It does, and it goes back to when they're making that calculation, your ability to earn and what amount amount would be, obviously, and what career path that you're in. If you've been out of school, you've been in school, how many degrees do you have, who's worked during the marriage, who hasn't, who's been the primary breadwinner for the family, who's taken care of the kids. All of these things come into consideration when it comes to alimony if you hit that 10-year mark.
A lot of discretion for the court to make a judgment call related to how they're going to apply those principles that we just talked about. And so having a lawyer through this process to lead, guide, and direct you is super important. Trying to go it alone is a very difficult process.
You guys were talking about finances. A question we've got here has to do with finances and how that can come into play. A question here, can a court order that my husband keep medical insurance coverage on our children until they reach 18 years old?
They can, and actually in Alabama, the age of majority is 19 years old. So they could order you to carry insurance for those children up to 19 years old. They can basically tell you that you're obligated to provide support, maintenance, that sort of thing until that child turns 19. They could absolutely order you to cover them on your insurance. Yes, sir.
I know we're getting ready to go to break. When we come back, let's talk about custody issues and how child support works, how it's assessed by the court, and ultimately how you need somebody to lead you through that process too.
Good deal. We'll step aside right here, our first break of the evening, an opportunity to remind you of how to get in touch with us, join the conversation. Also, find the firm of Hollis Wright on both Facebook as well as Twitter. Stay tuned. We've got more of the attorneys coming right up.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm. Thank you for watching The Attorneys. Now, we hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple. Provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to the show or related to other accident or injury-related topics, you can call, email, or text us. Or you can also follow us on Facebook or Twitter, or simply contact us by going to hollis-wright.com and click on the Contact Us link. We know your time is valuable, so thank you for spending it with us watching The Attorneys.
Welcome back into the Attorneys, talking about family matters and divorce in our program tonight. Would love to have you join the conversation. Also, a reminder, lawyers from Hollis Wright are standing by right now live to speak with you. That conversation confidential and will take place off the air. All you got to do is pick up the phone to take advantage of that opportunity. Josh?
I saw the firm fact coming back in that you've got to wait 30 days before the divorce is effective. What is there a policy behind that?
It is. It's called the cooling off period, quote unquote. It was instituted so that folks could have a chance to make sure that they really truly wanted to get divorced. So once you file a complaint, 30 days have to run before you can actually, a judge can sign off on your final judgment of divorce.
Now, do you find yourself in some senses almost serving in a counseling role to potential clients? Because I'm assuming there are plenty of times in your practice where you look at a circumstance and say, look, that divorce may not be the best benefit, or somebody has cold feet, not sure if they want to go through divorce, and they've got to kind of be counseled into, why don't you see how this goes?
Absolutely. And in this area of the law, you're dealing with people's families and the intricacies of their relationships with each other, and people don't act rationally during those circumstances. This is a highly stressful time, so it comes back, to me to say sometimes that your legal recourse may not be the best option for you. So, you want to listen to folks and kind of give them your best bet about what they should do in that sort of situation.
All right, when we went to break, I wanted to talk when we got back related to custody and support related issues, because I know that is an issue that impacts people that are going through divorce when there are children involved. First, let's address custody, then we kind of go into the issue of support. From a custody perspective, is there a standard custody order where a child falls into a standard process unless some agreement to the contrary? How does that work?
If you don't have an agreement about what's going to happen with the children as far as where they're going to live, who's going to take care of them, what the schedule is going to be in that sort of situation, the court institutes what is called the best interest standards. They're really looking at what's the best situation for that child and where they're going to place that child. In Alabama, everybody has a fair shot to ask for custody. If the court has to decide that, dad just has just as many rights as mom does in that situation. And then if evidence has to be placed in front of the court for them to make a decision, they really just look at the best interest of the child in that circumstance.
And so are there circumstances where a husband and a wife could get equal custody versus husband has structured custody on every other weekend? I mean, how does that normally work?
Right, and if you can't come to an agreement, which I help people every day that we come to an agreement as far as what we would call 50-50 split custody, where child spends maybe 1 or 2 weeks with mom and then rotates back and forth with dad on that rotating schedule. Usually courts don't want to do that because they're looking for the stability of the child in that circumstance. Yeah. They want to place them in a home and put them on a schedule that this is where you live, and then you go visit dad or go visit mom on these certain days and these certain schedules, that sort of thing.
And then I'm assuming the court ultimately is the one that makes the decision related to custody?
They do. If you have to put it in front of a judge, they will have to make a decision as far as who's going to have actual, what we call physical custody of that child, where that child sleeps every day, what school district they're going to be in, that sort of thing. And they'll also give the other parent what are called visitation rights and a visitation schedule. It's just something to consider when you're going through a divorce about, what the best interest of that child's going to be. That's really where the court's going to lean in that circumstance.
All right, so that addresses the issue of custody. Let's talk for a minute just about support in general. I mean, that is a pretty discretionary issue too. I know it's supplied, there's a schedule that applies, right, but it's somewhat discretionary as to who's going to pay what support, isn't it?
Absolutely. There's a calculation that the state of Alabama employs, and it's called the Alabama Rules of Civil Procedure 32. That provides a chart, so to speak, and you place both parents' gross incomes in that chart, and it spits out a number. It also takes into account child care and takes into account who's paying for health insurance for that child. It takes into account whether or not you're actually paying child support in a previous case for another child in that calculation. So if the parties can't come to an agreement about what a fair child support number would be, the court institutes that formula and it spits out a number, and that's fairly standard in that circumstance.
Gotcha. Well, it's amazing though when you think through this. I mean, talking about custody and support, how involved the court is. We get a lot of questions, and I'm talking about outside of the show during the week from families and folks that are going through this type of circumstance, and they want to know, hey, something's changed. There's a circumstance that's changed. I lost my job, or right, I want to move to a new location. how do I do that? And generally the response is that the court has to be informed, and ultimately the court needs to be notified, and we'll make some decisions associated with it.
Absolutely.
That's exactly the question we've got here. My ex-wife wants to relocate with our child who we share custody of. Can I stop her? So it goes right into what Josh was talking about.
Right.
there.
So if you have an order, an agreement from a court saying that I have physical custody of my child and I need to move for a job or for an opportunity of that sort of thing, you have to provide notice to the non-custodial parent that you are intending to make this move with their child, because the state of Alabama is going to protect that relationship between either mom and the child or dad and the child, so that you can't just leave the state and just not tell anyone. Basically, you have an opportunity to object to that notice. You can take it to a judge if y'all can't work it out, and they'll have a hearing and decide whether or not that child's going to be able to move with that parent, and they'll basically go with the best interest of the child at that point.
At what stage does support end? Like, how old does a child have to be where support would end?
Until 19 years old.
Okay.
Now, it goes back to the fact that you're supposed to be paying child support all the way up to that child's 19th birthday, right? So there are circumstances where the child could go past the age of majority, but you could still actually owe child support on a child that's over the age of majority for child support that you did not pay before they turned 19. So those are other circumstances we can get into, but up until 19 years old is what the law says.
And then I know we're getting ready to go to break here, but when we get back, I want to talk about if there's an arrearage, meaning you owe an amount
Right.
of back child support through, I guess, the Department of Human Resources down in Montgomery, or whoever the entity
Right.
is. We'll talk about that when we get back, because I do want to talk about that and kind of what can happen to you if you don't pay your child support.
Right. Yes, sir.
All right, good deal. We're stepping aside right here, our final break of the evening. As we do so, a reminder how you can get in touch with us. Also, the attorneys from Hollis Wright standing by live. Take advantage of this opportunity to get some free legal advice from the attorneys of Hollis Wright. Stay tuned. More of the attorneys coming right up.
I'm Carter Clay with the law firm of Hollis Wright. When someone whose unreasonable conduct causes an injury to someone else, the law says that person is negligent. So it seems the injured person should receive some type of damages, right? Not always so in Alabama. In tonight's Legal 411, we answer the question, what is contributory negligence and comparative fault? Alabama is one of only 4 states in the nation to withhold damages based on contributory negligence, meaning if you are at fault even just a little, you cannot be allowed any damages in a case. For example, in a case where a defendant may be 99% at fault for hurting you, if you are found to be 1% at fault, Alabama law says you get nothing. 4 states, Virginia, North Carolina, Maryland, and Alabama, plus the District of Columbia, are the only places in the country where a defendant can completely avoid paying if the injured person is even 1% at fault. This is very different from comparative fault, the measure used in 46 states. There are 2 versions of this system, but both essentially allow money damages based on the percentages. For example, if the injured person was 20% at fault for causing an accident, then the recovery for medical bills and wages is reduced by 20%. Numerous studies across the country show that people who live in comparative fault states believe this system of justice is more fair. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. Remember, a competent lawyer will always respond to every question you send in. That's our pledge and promise to you.
Welcome back into the Attorneys, talking about family matters, divorce, and tonight's show. This is our final segment, about 8-9 minutes remaining in the show. So the clock is ticking if you would like to speak with the attorneys of Hollis Wright, who are standing by live to speak with you. Just a few minutes remaining to take advantage of that opportunity. Josh?
We're addressing a lot of different topics, and we'll get back to kind of where we were, but I want to ask a couple quick questions that always come up in these shows. One is retirement assets. What happens to retirement assets if you get divorced? Are they subject to the divorce estate where they're going to be allocated equally? How does that work?
Right. We'll go back to that 10-year mark. Once you make that 10-year mark, retirement assets can be divided by the court if you can't come up with an agreement. You're not going to be dividing them more than 50-50. So the person that actually has that benefit is not going to lose more than 50% of that benefit in retirement, but that could be awarded to your spouse. And in that circumstance, what happens is the court enters what's called a qualified domestic relations order, and we call it a quadro. And it basically directs that fund or entity to make the division that the court's ordered, and it comes directly to you after that point, once you hit that benefit and it starts paying out.
All right, so when we went to break, we talked a little bit about what happens if there's an arrearage, what happens if you owe back child support. How does that process work? And I mean, people can actually go to jail for this, can't
Well,
they?
absolutely, they do every day. What you would have to do in a divorce situation, you would take or talk to an attorney, and they would file what's called a petition for contempt, a petition for rule nisi. You're basically asking the court to acknowledge that, hey, a judgment was made in this amount as far as a child support, monthly child support amount. My ex-spouse has not paid this amount in X number of months. You basically prove that to the court. They reduce that to a judgment amount. That person will then be ordered to keep paying their child support if the child is still under 19, plus that arrearage amount. So they'll reduce that overall judgment that they get to maybe like $50 or to $100 on top of your original child support amount, so try to recoup that money going forward. Now, let's say that someone just refuses to pay child support and they're not working, or they are self-employed, so you can't tax their income with what's called an income withholding order. You get that petition for rule nisi filed against them, get a judgment against them in that amount, and the court can actually threaten them with jail time if they do not pay their child support. And that happens all the time.
You know, the interesting thing about this area, David, is it affects a lot of people.
It does.
And the interest that gets tacked on for back child support is significant. One of the issues that people a lot of times will have as to why they're not paying their child support is, I've had a change in circumstance, like I lost my job, or like there was a layoff for a period of time. When that happens, and I know Matt, I can speak for Matt here, he would tell you, go back to the court, tell them and explain to them the changed circumstance, because there are ways that you can amend your child support order so that you don't get yourself in arrearage. Because once you get into that, it's like owing an IRS lien. And once you get into that and it gets capitalized on top of interest and interest and interest, it can get completely out of control, and you can get yourself in a lot of trouble, both civilly and also criminally.
Kind of a snowball effect,
no question.
if you will.
Absolutely.
Another question we've got here, I have a child who is applying for college. Is there a way I could ask a court to order my ex-husband to pay for it? What are the general rules and laws surrounding the payment of a child's education?
Right. The Supreme Court of Alabama has gone back and forth on this issue. Most recently, they have ruled that you cannot order a parent to provide post-majority child support, post-minority support for a child that needs to go to college. You can't order somebody to pay for a child that's over the age of 19 to receive education from a university or college.
Okay.
Now, you can always work out an agreement, because I always go back to an agreement as an attorney. As far as if you can work that out with your spouse, the court's perfectly fine with that happening, but they will not order somebody to pay for support going after the child's 19 in the form of college education expenses.
What about a change in circumstance in a relationship? For example, a couple gets divorced, there's child support obligations, and the father has an obligation, hypothetically, to pay the child support. The wife gets remarried. That doesn't impact child support obligations, does it?
No, it's going to come back to both of your incomes. Now, if somebody's income changes or there's a significant change in the circumstances that you have to prove to the court, you can always revisit that amount. And child support amounts get changed every day based off of people's circumstances, living situations, income levels, and the needs of the child. So that can be changed, but not in that circumstance alone.
Now, let's also talk, same question related to alimony. Let's assume in that hypothetical that the husband is paying alimony to the wife. wife, the wife gets remarried, does alimony continue generally?
Everything's going to continue until you ask a court to change it or until you can reach an agreement that it's going to stop. Now, in that circumstance, you could show that the wife's needs are no longer what they were before. She's got a station of living that y'all were comfortable with, and the court could order that alimony be stopped.
Gotcha.
The only type of alimony that can't be modified after a judgment is rendered is lump sum alimony payment. So if you've got one lump sum, then that can't be changed going forward, but everything else is modifiable.
You got 3 minutes remaining, but I want to get this one more question. And I have 2 children with my soon-to-be ex-spouse. Can a court order that our children be split between my husband and myself, or one lives with him and the other lives with me?
They can do that because the court in Alabama has a great power to kind of put down any visitation or any custody schedule they see fit. They generally do not like doing that because it's always in the best interest of the child, and they usually want to keep siblings together in that circumstance. But the court could do that if they wanted to. And some folks work out agreements where that's the case. Like I said, it's very hard to put these square pegs in round holes, but the court does their best to do that.
How about just real quick, we got enough time?
We do,
All right,
yeah.
just real quick. What happens in the circumstance where a child has an opinion where they want to live? Does the court entertain that? Does it matter what age they are? I mean, how does that work?
Right, it absolutely matters how old they are. The courts can sometimes appoint, and sometimes party can ask for what's called a guardian ad litem to be appointed, and that's an attorney that comes in that the court appoints to represent the best interest of the child. They're not an advocate for either side, but the child can talk to them, they can interview the child, and it becomes almost like an eyes and ears for the court. That guardian goes back and can offer a report to the court based off what the child's telling them, what they've witnessed, what they've seen, what their preference is. All of that can be taken into consideration, but it definitely has to depend on the child's age and that sort of thing.
You see why we got guys like this on. He knows his stuff. And that, I mean, these issues are issues that come up all the time, and you need to be surrounded with a guy like Matt if you're going through this circumstance without question.
Less than a couple of minutes remaining, but I want to give both of you the opportunity for a final thought. And Matt, if you would, you go first, please.
Absolutely. I would always advise everyone to seek counsel in these circumstances. Sometimes you feel like that this can be taken care of without much heartache or how much money being involved, but it's much better to do this right the first time. And we have wonderful divorce lawyers, family law lawyers in the Birmingham metro area. I would always encourage everyone to go see somebody like that if you're going through a circumstance like this, because this can be very, very stressful.
Yeah.
You know, what I would say, and whenever we do these shows, you know, my heart goes out to the people that are going through this, because I hate, you know, I haven't experienced it personally, but I hate the circumstance for people.
Yeah.
But, you know, what I'd say is this: if you are going through the circumstance, or you're considering divorce, or you've got a custody-related issue or a change in circumstance, getting somebody involved like Matt, who knows what they're doing, that at least can hold your hand through the process, is super important. Sometimes you feel strength in having help. And help sometimes comes by way of counsel, and so this is a good example of that, and this show's been a good example of that, where we want to be able to use an advocate to be able to help you.
Absolutely. Matt,
Matt,
Josh,
good job.
Thank you very
thanks for
much,
the
guys.
time. Thank you for joining us as well. We appreciate it each and every week that you choose to join us here on a Sunday night on The Attorneys. We appreciate it. As we head to break, if you have a question, is still the opportunity to reach out to the firm of Hollis Wright. You see it right there. We'll see you next time here on The Attorneys.
Thanks for watching The Attorneys, sponsored by Hollis Wright.